All right. The first bill that passed this year is LB 103 that allows for the use of technology in trials per agreement of counsel. This issue came up yesterday when we were in South Sioux City. Some judges conduct detention hearings by phone because they have to travel and they can't be in two places at one time. So the question was asked of me, is this statute going to apply to those who have to have actually in-person hearings? I think the answer is no, but the thing to remember here is Supreme Court rules trump state law. And right now the Supreme Court is reviewing a rule that has been brought to the judge's attention regarding detention hearings. Years ago, 17 years ago, there was a case out of Riverside, California that went to the U.S. Supreme Court that said if there was a defendant incarcerated, there must be a probable cause finding by a judge or else they have to be released. So based upon that case, Chief Justice White in the Supreme Court issued a rule, but in the rule for juvenile court and juveniles, they said you had to have a probable cause hearing. So we have raised that issue with the Supreme Court. There was a proposal that actually came out this morning from some judges that we do 24-hour probable cause findings. And my guess is the Supreme Court will do something to accommodate these issues. So there'll be some sort of Supreme Court rule that will come out, I am certain, that will allow for detention hearings, including those by phone, to accommodate those judges, particularly who have multiple jurisdictions within their district.
Larry?
Yeah.
I don't think 103, because I drafted 103,
Yeah.
went to that issue.
I agree, but
There's another
your
statute that covers that.
your colleagues, though, in South Sioux.
Oh, well, Rager? And you listen to it?
So. I don't have a mic. I'll just shout. This is a mic for the video. It's a mic for the video, not for the, so I'll just speak louder. 216 you're going to hear in a little bit, and this honestly is one of the best presentations I've heard in quite a while. I just think it's terrific. That'll be after me. This is the sex trafficking bill, and Sandra Markley from the County Attorney's Office.
This is the, if you want to put this on.
I'm going to use my entire allotted time trying to get the microphone. As I mentioned, this was a case that Sandra brought to my attention because I didn't notice that it applied in the juvenile code. But if you're under the age of 18 and you're picked up for prostitution, you're treated as a victim. So the police must take you to the Department of Health and Human Services, and you fall under 43-247-3A. And in fact, they added the language including prostitution to that clause. And that's part of this overall sex trafficking bill that passed this last session. 265 is a bill that defines kinship care so that we can fast-track kids to relative placements. And that was the purpose of this bill. And it also added a Class 1 misdemeanor for a violation of the Licensing Act. 269 was a cleanup bill. If you recall, last year the legislature created its own commission on children to look at a variety of issues. There are some things that this bill did. It added 2 non-voting members, Kim Havakati, from the Foster Care Review Office, Julie Rogers, the Inspector General, are now part of the Children's Commission as non-voting members. Also, there'll be an analysis of the Juvenile Services Delivery Project, which is LB 561. And then there's also the 4E reimbursement issue with the department. In addition, the bill also provides to ensure that every minor has adequate health coverage. We're supposed to review that every 6 months in court. And their discussion on 216 will talk about this a little bit further, but we want to make sure these youngsters aging out of the system get what they're entitled to until they're 26 under the new health care bill. 530 is the foster care reimbursement bill. The purpose of this bill was to establish foster care reimbursement rates that actually meet the cost of raising these youngsters and caring for them. There are some pilot projects established regarding this, and then there's a committee that's been established that will convene and has to report to the legislature every 4 years beginning in 2016. Corey covered most of these things. I just want to talk a little bit, just to underline that 561 does not cover 3Cs. Those are the emergency committals because of mental health issues. That stays the same. There are new definitions under LB 561. Senator Koash had introduced a separate bill that would have defined parents, guardians, step-parents. But as part of his definitions, he had really excluded the opportunity of a non-custodial parent getting possession of a child who had gotten picked up. So if a police officer arrested somebody, brought them in to the Justice Center, and wanted them released to a parent, if the custodial parent was not available, under the proposal, the non-custodial parent could not take the child. So I had talked to him, and there was also some issues. We wanted to ensure that if somebody was eligible to be a party, that we could get them counsel, a grandmother. In my circumstance, it was a grandmother that had no money, but she would have been able to intervene if she had the money, and it was important we let her, so I appointed her an attorney for that purpose. So what came out of is he amended his proposal. It was amended into 561, and the language is so broad that arguably we can appoint counsel for anybody in juvenile court. That wasn't the intent, but that's how it came about. The Crime Commission, Corey mentioned this, there's 2 new positions that have been filled for diversion, and also somebody to oversee the community services grant awards and to assess how those are doing. And those aid grants were increased by $1.8 million and $3.8 million next year. Originally, when that was passed, it was supposed to be funded at $10 million. We never even got close to that. Now we're at least halfway there. I've heard that this next session they're going to try and get it up to $7.5 million. And it requires an in-kind match from the county, which is pretty easy to do. And these are really great opportunities for people across the state to develop new programs and services for the benefit of kids. You have to have a juvenile services plan that's approved every 3 years by the Crime Commission. Because they have somebody now assigned, they can assist you and provide some technical assistance if you need it. A contiguous group of counties can go together to apply for these funds. So I doubt there's anybody here that has this issue, but if you're from a county that has never applied for these funds, now is the time, because the resources are there to assist you. And Corey talked about the fact that OJS evaluations are no longer needed to commit somebody to the YRTCs. I should also mention that, I think maybe he did mention this, there's an OJS subcommittee to the Children's Commission, the legislative commission I mentioned. I'm part of that, he's part of that, Ellen Burkowski co-chairs it. We're supposed to be getting some recommendations to the legislature. The idea is to improve the quality of services and the programming at the YRTCs. And he did talk about reentry. I've just got this up here to summarize. And your jurisdiction is going to handle some of these issues differently, because a lot of it is based upon where judges have to be with travel and everything else. We're going to talk about it within our EYES team. One thing that we've talked about is perhaps having some sort of a review without a hearing before the child's released to make sure that the plan's in place and everybody's aware of what it is, and then scheduling the hearing shortly thereafter when they are released. But the statute requires that probation have contact with that youngster when they're released within 48 hours. Upcoming issues. LB 464 was Senator Ashford's bill that would require all cases to begin in juvenile court if the individual is younger than 18. We're one of 2 states where the prosecution has the discretion to file it juvenile or adult. The County Attorneys Association and some others had some pushback on it, so they decided to table it. They're going to bring it back this next session. My guess is there'll be some sort of a hybrid approach. The high-grade felonies can start in the adult system. The low-grade felonies and misdemeanors will start in the juvenile system. As I mentioned, recommendations for YRTCs. There may be some other recommendations from the Children's Commission that the legislature will consider. Juvenile code guardianships. It wasn't mentioned during the case law review, but there were 2 cases that came down this past year from the Court of Appeals that cited a Nebraska Supreme Court case that came down about 2 years ago. And in that situation, what the Supreme Court said, is regardless of whether it's a probate guardianship or a juvenile code guardianship, we're not going to find any distinction. We're going to treat those the same, and it's parental preference that applies. So in the cases that came down from the Court of Appeals this year, one of them was a situation where a child was placed with a stepfather in Gothenburg. That was his parent. That's who he knew as his parent. Mother lived elsewhere, didn't have significant contact, but in that situation, because there were no allegations against mother, parental preference trumped best interest. Best interest was not an issue. The court awarded possession to the mother. In another situation, there was a father who lived in New York. He was in the military, had very little contact with his child. A week after the protective custody hearing, he applied to have possession of the child. No allegations against him, but there was some testimony that he had been abusive in the past. What the Court of Appeals said, it's not the best interest issue, it's parental preference. There's no allegations here against this father in New York State. Even though his contact has been minimal, he gets possession. So there's a committee that's been established through the Supreme Court Commission on Children that's going to review this issue. I don't know if there's going to be recommendations that come out in time for this session, but it's certainly something we need to review. Funding is always going to be an issue. LB 561 funding may be an issue, so I'm sure that's going to be reviewed in this next session. And as I mentioned earlier, Douglas County and their need for another juvenile court judge. This was a quick overview, but any questions over what I've gone over?